morning, Mr. Cosden, Ms. Richards.
Good morning, Your Honor.
Good morning, Judge.
Mr. Cosden, do you wish to reserve 5 minutes or up to 5?
Yes, Your Honor. I would ask to reserve 5 minutes for rebuttal, please.
Okay. We're ready whenever you are.
Okay, I'm not sure that this camera is pointed correctly.
It looks good. It looks good. It looks like it's just right.
Thank you. Good morning, Your Honor. My name is Christopher Cosden. Before the court is Getz versus State, case number 2D19-1100. Your Honor, this in the trial court, Mr. Getz was, convicted of vehicular homicide. He was also convicted of DUI. We do not challenge the misdemeanor DUI. We challenge only the vehicular homicide. There were two major errors by the trial court in this case. The trial court erred by denying the defendant's motion for judgment of acquittal, which was based on a lack of evidence. Also, the trial court erred by not allowing Mr. Getz to present the testimony of a defense witness, that Mr. Paulette. That testimony was proffered and is available for the court to review. The elements of vehicular homicide are, of course, the killing of a human being by the operation of a motor vehicle in a reckless manner likely to cause the death of or great bodily harm to another. That last element was not proven by the state. In fact, the state put on little or no evidence tending to show that—
Mr. Cosden, they did have an eyewitness, right? The gentleman on the motorcycle who saw the contact. And there was debate about, I know, between the state and the defense as to what he actually saw. But there was testimony from him about what he saw, these two vehicles on a road. He saw them, basically making some type of contact. Isn't that in and of itself a jury question? The way, the credibility of this witness and to, determine, whose version of what he saw is accurate. Isn't that in and of itself a jury question?
Your Honor, had the witness been present and observed the driving before the collision, perhaps that would be correct. However, the witness testified that at the point at which Mr. Alwyn saw the vehicles, they were basically making contact. He did not see the driving before the vehicles collided. Now, there's no doubt that the vehicles collided. That happened. The question before the trial court was, how did it happen?
There's some evidence that he observed the vehicles before they crashed. He even estimated the speed he thought they were going. If he had only seen the moment of the impact, he wouldn't be able to have estimated a speed.
Well, that wasn't very well developed in the trial testimony, Your Honor. It appeared from the trial testimony that Mr. Alwyn did testify as to speed, although his testimony as to speed conflicted with other states' evidence as to speed. But Mr. Alwyn clearly stated in his testimony that he did not observe the vehicles before the collision occurred.
But he did testify that he saw the car make contact with the van. Am I correct in that?
He saw the car make contact with the van.
Okay.
So
the initial contact between the vehicles was initiated by the car, not by the van.
No, Your Honor, that's not clear.
Okay. Well, doesn't your argument go to the weight, though, of this evidence? I mean, there clearly is this evidence. And then, of course, we have the separate issue of the Bush decision about whether or not there's, the special standard exists anymore for circumstantial evidence cases, which I don't think it does, but I'm going to let you address that because that's obviously a very big part of this. But You know, I mean, agreeable. I mean, I agree that there is not a substantial amount of direct evidence, but there is some, you know, and
There really
how
is.
persuasive it is goes to the weight of the evidence, and that's a jury question, the way I see it. And then, you know, even that being the case, help me understand why you even have an argument here on the special standard after the Bush decision.
Well, Your Honor, we do not have an argument on the special standard after the Bush decision. I addressed that in the reply brief. Bush was decided about a month after the initial brief was filed in this case. But the question here is not interpretation of the circumstantial evidence. The question presented to this court is whether there was sufficient evidence to get past a judgment of acquittal. Here,
Doesn't that evidence have to be considered in the light most favorable to the state? Isn't that the standard?
yes, Your Honor.
So the judge has to look at all the evidence and consider it in the light most favorable to the state. And in the light most favorable to the state, there's direct evidence on causation. That in the light most favorable to the state, the car made contact with the van, so initiated the crash as they two were speeding down the road together. So in the light most favorable to the state, I mean, any reasonable judge is going to say, hey, this is up to the jury to determine the weight of this and sort this out. It's not I mean, taking this case from the jury at this point would actually be a bad thing if a judge did it based on the law and the facts of this case.
Your Honor, what is lacking here is evidence of driving in a reckless manner. Nobody saw what happened before the collision. Now, Mr. Alwyn saw the—
Is driving at 110 miles an hour while intoxicated reckless?
Your Honor, that was not the testimony of Mr. Alwyn. Mr. Alwyn said that—
But it is evidence in the record that was presented by the state.
Okay. The evidence of fast driving came from interpretation of data in an event data recorder in the Kia. Now, that interpretation requires multiple levels of inference. This is set out in the brief. Basically, the witness who interpreted the data first looked at the data. The data itself is not in evidence. Then he made conclusions from the data. And then, jumping from the conclusions to the data, he made at least one more inference to establish that there was somehow operation of the vehicle in a reckless manner. Now,
if that were the case, if relying on evidence from a data recorder caused the problem of stacking inferences as you described, wouldn't that be the case, say, with evidence adduced by the state to prove that a substance was cocaine or PCP or something? In other words, you know, you're relying on data and some sort of chemical test kit, and then you're relying on an expert to interpret that data. So would this be the end of all evidence of that nature, because that inherently requires stacking of inferences?
No, Your Honor. In a case involving a test of a chemical, ordinarily the state would put on a laboratory analyst, the person who actually did the test. The laboratory analyst would describe what they did and conclude from the data that this substance was in fact cocaine or whatever it was. No inference is required there beyond interpretation of the data. That's not what we have here. What we have here, assuming that the evidence was properly interpreted, and I don't know that it was, that's a different question for a different court on a different day, but assuming the evidence was correctly interpreted, we have two problems. The first is conflicting evidence the evidence from the data recorder conflicted with Mr. Alwyn's testimony. And in fact, that was a very major conflict. But more important, the inference from the data does not establish reckless driving. The inference from the data, assuming that it's
is the ultimate legal question, in other words, the inference from all of the data that the jury is required to decide whether to draw, does that count as one of the stacked inferences? I don't think that's the way the analysis works. In every case, there is evidence, and there could be evidence from which an inference could be drawn to make a factual finding. But then the ultimate inference that factual finding constitutes reckless driving is not one of the inferences we usually consider when we consider the stacking question. Is that correct?
It may not be one of the inferences that we usually consider, but it's certainly one of the inferences that we must consider in this case.
Why is that?
Ordinarily,
Mr. Cosden, I think could you repeat that, Mr. Cosden? You broke up a little bit, at least as far as I'm concerned, on my connection.
I'm sorry, Your Honor. Ordinarily, in a reckless driving case, what will happen is the state will put on an eyewitness who will say, I saw the driver of the vehicle do A, B, and C, whatever it is that the witness says. That's direct evidence, or can be direct evidence, of reckless driving. No inference is required. What we have here is circumstantial evidence, but circumstantial evidence that requires multiple inferences.
So just so I understand it, I mean, the evidence we have is that he was going over twice the speed limit, twice the posted speed limit. Are you calling into question that being circumstantial in nature? I mean, based on this device in the vehicle, he was estimated to be going 110 miles an hour in a 50 mile an hour zone. I mean, is that your position, that evidence is not reliable and there's no other reliable evidence as to his speed, because the speed in and of itself would be reckless driving?
Well, I'm not sure that that's correct, Your Honor, and I'll be happy to submit a supplemental brief on the issue of speed alone being reckless driving.
Well, let me put it to you this way. Any jury sitting listening to this case, if they were persuaded that he was in fact going 110 miles an hour, I doubt you could talk him out of saying that's not reckless.
Well, assuming that the jury believed that evidence, and assuming that that evidence was properly admitted.
You haven't raised it. I don't believe you've raised an issue on appeal regarding admissibility of the evidence, have you?
No, Your Honor. The question is sufficiency. However, we did raise on appeal the issue of stacking of inferences, and we've already been over that. I don't think I need to go back to it. But the only way we can get from where we start, from the eyewitness testimony to the reckless driving, is by inferring first that the data in the event data recorder correctly represents what happened. Of course, we don't have that data. That data is a number or a series of numbers, which are simply not in the record. Then we have to infer from that there is a way to determine speed, and perhaps that would be a permissible first inference. But then we have to go from speed to another inference that simply driving fast was reckless in nature. That is
Mr. Cosden, let me ask you a question?
Yes, sure.
Okay. Let me ask you a question in that regard. The arguments that you're making sound more similar to pretrial motions, like an Daubert motion, that perhaps that should have been raised. So I'm wondering why those arguments are being raised now. It seems to me that if we look at the evidence that was before the court at the time the motion was made, that the evidence and the light most favorable to the state, you'd have to admit, there was this evidence of the box, the data recorder showing that the mileage was at a high speed. There's evidence that the defendant was over the legal limit. And then there's evidence from the eyewitness that the car hit the back of the van. So given all of those things, the court and with what Judge Morris said is that this is a matter to be tried by the jury at this point in time based upon that evidence. But I want to get to the testimony before you run out of time. I want to get
Smith, yeah, we're way into his rebuttal time, so you might want to get to your question so he can answer it.
To the Paulette testimony that was excluded, to your second point.
Yes, Your Honor, that's a major constitutional violation. We know from a variety of cases interpreting the Sixth Amendment to the U.S. Constitution that a defendant has the right to put on testimony in his own defense. In several cases, Chambers v. Mississippi and Washington v. Texas, both of which are cited in the initial brief, the U.S. Supreme Court so held. In Florida, the rule seems to be that where evidence is relevant to show a reasonable doubt, that evidence should be admitted. Veneer, V-A-N-N-I-E-R, state, for example. Here, the testimony of Mr. Paulette would have been that he was very, very drunk. Now, that certainly raises a reasonable doubt as to whether or not Mr. Paulette, driver of the van, moved into the outside lane and struck the Kia, or whether the Kia moved into the inside lane and struck the van.
Now, go ahead.
Hang on, everybody. Mr. Cozzin, you're down to 2 minutes left of your rebuttal time. So you either gonna grind it all up on the front end or you're gonna save it. So what's your call?
Well, Your Honor, I think I would like to save the remainder of my time, but I would point out to the court that the argument for error in the denial of Mr. Paulette's testimony is set out in the initial brief.
Okay, thank you. You have 2 minutes when we come back.
Thank you.
Ms. Richards?
Good morning, Your Honors. Just to give you a bit of the background, as you all clearly know it's more than just doing 110 miles an hour at 11 o'clock at night after leaving Hooters. It's a breath alcohol of between 0.192 and 0.204. It's also a matter of the brakes never being applied. And there was testimony. Mr. Allen said, and you're right, Judge Atkinson, he did testify that he witnessed about, and I can't tell you whether it was in the proffer or direct testimony, that I don't quite remember, but there was in the record that he saw the vehicles for about a minute before the accident. But his direct testimony on transcript page 305 to the jury was, at that point, after they decided to hit, and the sedan smacked the back end of the van pulled away, fishtailed, and the sedan went into the ditch. So yeah, there is eyewitness, there is speeding, there is high alcohol levels. And to talk about the black box, just briefly.
You mind if I jump real quick, and we're going to get back to the black box. want to take this opportunity to jump issues real quick. Given all that, isn't it still possible that if Mr. Paulette's testimony was adduced, given his level of intoxication, that the jury could have found that he was the sole proximate cause if the jury found that his vehicle was the one that had crossed lanes, and that it may have been impossible for the defendant's vehicle to have applied the brakes in a timely enough manner to avoid the collision?
Your Honor, I would have to disagree with that because it's not merely Mr. Allen's testimony. It was also Detective Andrew Satterley. And he testified in detail on pages 513, 530, 541 about where the gouge marks were, where the oil spill was, where the debris was. He was very clear, and he said, and I quote,
"Is it possible that because I think we all know that evidence, but I mean, is it possible that the jury could have rejected that testimony and said, no, I still believe that the victim's vehicle, well, it wasn't one of the victims, that it was Mr. Paulette's fault? And if it is possible, wouldn't it be error to have not had to have, if it was relevant, because the jury could have decided that Mr. Paulette was the sole proximate cause, what would be your argument for why it was so prejudicial that that relevant testimony should have been excluded and it's not a problem on appeal?
Well, Your Honor, I would say that under your hypothetical, even if there was error, it would have been harmless, because I disagree that the jury's verdict would have been any different than what they found.
But quickly, before we get to harmlessness, what would have been the rationale, an abuse of discretion standard, for excluding that testimony? Why would it be so harmful or prejudicial that if it was probative, it should have been excluded?
Well, there's two answers to that. First, if you look at the record itself, the defense counsel made it very clear when they proffered the testimony from Mr. Paulette, they were not asking him about his alcohol level. They were not going to ask him about his medical records. All they wanted him to say on the stand was that his mother was law enforcement so that they could prove bias. So the argument now is not properly preserved that his testimony regarding his intoxication is what they wanted, because defense counsel specifically and clearly stated, no, we want him to testify that his mother was law enforcement. And under that circumstance, there is no relevance whatsoever to what his mother does for a living as to a sole proximate cause of a vehicular homicide. So that is the first answer. The second answer is,
well, hang on.
Ms. Richards, I think Judge Smith is
that evidence does bear on his credibility, though, doesn't it?
Your Honor, it's not his credibility, because on his proffer, Mr. Paulette testified, I don't remember a single thing about the accident.
No, my point is that his mother is law enforcement bears on his credibility, does it not, in this circumstance? I mean, you know, the presumption being he got cut a break because he's related to the law enforcement family, right?
Except he didn't get cut a break. He was charged with DUI. And no, his mother has nothing to do with the cause of the accident. And because he was charged with the DUI.
Well, he got charged with DUI, but he didn't get charged with the accident. And whether, you know, there's other evidence about the accident. We've discussed all that. But the question is, I mean, is this something the jury should have known? Should they have been able to assess this man's credibility, knowing that his mother is law enforcement of the very agency? It's the same agency, right?
I believe it is.
Right? It's the same agency, isn't it? Yeah.
Yes,
same
Your Honor,
agency.
I believe it is.
So in other words, her colleagues were investigating this accident. You don't think the jury should know that?
No, Your Honor. No, I don't, Your Honor. Because
So if I had one of my lawyer children show up here to argue a case, shouldn't I be telling everybody that, hey, that's my kid there?
Your Honor, I think there's a very different idea than somebody being accused of an accident where someone died and an argument in front of your court, Your Honor. There's just no evidence to support their hypothesis that anyone other than the appellant was the sole proximate cause of this accident.
Well, then oh, go ahead, Judge Smith.
Yeah, I don't know if my speaker, can you hear me? My speaker. Yeah, I can't get my speaker to work, shoot.
I can hear you,
I
Judge
hear you
Smith.
fine.
Can you hear me? Okay.
I hear you fine, yeah.
So my question on this point is before, and I understand the law enforcement, the bias issue that was developed, but before that part of the proffer was made, there was a proffer from Mr. Paulette's testimony about what he remembered from the night of the accident. And I really thought that's what was being built up here in the appeal. I think they've sort of let off of the bias issue, although that is developed in the record and we can see it from the transcript. But before that, you know, I have an issue with a defendant being precluded from presenting their theory of the case, where you have this other car involved in the accident and their testimony is precluded in its entirety based upon the proffer that was made. And clearly we know that they were above the legal limit and they don't have a memory. Now I see there might be a dilemma, because what can they, if they have no memory of the accident, the only testimony coming in is, yes, I was drinking, I drank this much, and I don't remember anything else. So, but can you not agree that the fact that another car involved in the accident is relevant?
Your Honor, I think the other car involved in it is of course relevant to the accident. However, it's not just, the relevance is not whether Mr. Paulette
Well, Ms. Richards froze, unfortunately.
Ms. Richards?
Harris?
Ms. Richards, I think we might have lost you, your feed.
Well, this certainly doesn't happen in live court.
Well, I might freeze up sometimes like a deer in headlights, but no one notices.
This remote arguments are a good thing, but they're not a perfect thing.
Maybe she'll reconnect.
Yeah, I think we've lost her.
Judge, she has a phone number that hopefully she can use to call in.
Okay, there she's back.
you see me now.
Yes, we hear you now, but we lost you for about a good minute and a half.
And I'm sorry, because that minute and a half, I won the argument. I tell you.
That's the way it always works for me.
Are you still there?
Okay, I know. Okay, good Lord. I'm so happy when I can get back in the courtroom. I apologize for asking this, but what was the last thing you heard, Your Honors?
Well, it was a minute and a half ago and it was brilliant, but you know, you were in the middle of it, so I don't know if I can piece it together for you.
All right, then let me just phrase it this way. There is no evidence whatsoever to support the defense's hypothesis of innocence, because it's not just the testimony of Mr. Allen, the eyewitness.
Well, do you mind if we stay back on the precluded, the evidence that was not admitted? For the sake of discussion,
Yes.
if we decide that it was probative, that if admitted, there was at least a possibility that the jury could have relied upon it to determine that Mr. Paulette was the sole proximate cause. I'm not sure you answered my question about what would be the rationale for excluding it. Is it, what was the rationale? Why would it be so prejudicial that if it was probative, it should be excluded?
Yes, sorry, Your Honor, and I do have this down. The trial court themselves excluded it by saying that there was no relevance to the information that defense was trying to bring in. The testimony would not have sought to educate the jury on anything that wasn't already there. Any error, if you choose to see it as an error, would be harmless because there was an overwhelming amount of evidence on the state side that even if this was an error, it would have been harmless because it would not have affected the jury's verdict in this case, Your Honor. Every time I let go.
We can still
I'm
hear you.
sorry, I think it's every time I let go of the space bar to stop speaking. Yeah.
It's okay. We're hearing you fine.
We can hear you.
Yeah,
Okay.
and I do encourage everybody to let Miss Richards make her argument because she apparently has an unstable signal. So, yeah, so you might want to just tell us everything you want us to hear before we lose you again.
I appreciate that, Your Honor. And as I was saying, on the record in page 359, the trial court's rationale for excluding it specifically was there had been, quote, no evidence presented that Mr. Paulette's driving pattern contributed to the crash, that Mr. Paulette's actions did something to contribute. No reasonable jury could find that Mr. Paulette's intoxication was the sole proximate cause of the crash that killed Mr. Rutherford. And that is in fact the case. He would have to be, for this court to find it a harmful error, there would have to be evidence that Mr. Paulette's intoxication would be the sole proximate cause, and it is not. If there are any other questions, I'm kind of tempted to make the most out of getting that out in one piece.
Any questions? Okay. Thank you, Miss Richards.
Thank you, Your Honors.
Mr. Cosden, 2 minutes.
Thank you, Your Honor. The reason that there is no evidence that anyone other than the defendant caused the accident was that the evidence that could have supported that conclusion was excluded at the trial.
You admit that the only evidence would have been his intoxication, right? That he would have admitted that he was intoxicated.
We assume that that would have been his testimony.
Well, don't we have to assume? I mean, there was a proffer. We can't sit here and speculate. We have to. The argument you're making is that what was excluded was his admission that he was intoxicated.
That was what was in the proffer. Now, what we do not have clear evidence to support once of the events. We've already been over that. I don't have to go through it again. We simply do not know what led up to the collision. Now, had Mr. Paulette testified, certainly had the jury believed Mr. Paulette, the jury could have found that Mr. Paulette was very much under the influence. And now we have a completely different case. We have two people seriously under the influence who collide. Now, where the jury might go with that, I don't know. But
so the jury would have, you'd agree that the jury would have to conclude that that Mr. Getz did not contribute, that none of his negligence, his actions did not contribute to the accident at all. That's what they would have to conclude, correct?
We don't know what the jury would have concluded.
But that's what would have been necessary to support a finding of not guilty, right?
Your Honor, we do not know what the jury would have concluded. The jury may very well have decided the case on something that we cannot speculate about.
But if we were
You're
to
at 2 minutes, just so you know.
oh, sorry, George.
That's okay. I just want everybody to know, but you never know what a jury's going to do, right, Mr. Cosden?
That's correct, Your Honor.
Okay. So I think you want to wrap up real quick? I didn't hear those last words, but I think they were brilliant. we're having a problem with our sound. So we can't hear you now, Mr. Costin, for some reason.
I,
Oh,
Your
there, you're back. Okay.
Honor, I'm probably out of time. I would ask this
You are.
court reverse the conviction for vehicular homicide and remand the case to the trial court for further proceedings.
Thank you both very much, and thank you for your patience with our technology, which hasn't been perfect. And I think all of our technologies have all impacted this, but thank you very much. We're all through. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Mr. Costin?
This is a great example of why we should go back to live oral arguments.
I'm with you 100%, Mr. Costin. We're going to get there as soon